Welcome again to the Lifetime webinar series. I am Chelsea. I'm your host today, and I am joined by Martin Hawes, who has been telling me all about his morning swims in the ocean. Very brave. I'm not sure it's warm enough yet, though, for me. So, and we've got Liz Coe here as well with us. And today we are going to be talking about trust, family trust, wills and estates, which is a very, we tend to find quite a hot topic for people. So as we'll get into that shortly. Obviously, our lifetime retirement income is they offer, I'm getting very tongue-tied this morning. We do reliable retirement income solutions designed to last for life. We'll all start with our normal disclosures. So Lifetime Asset Management is the issuer and manager of the Lifetime Retirement Income Fund. You can find our product disclosure statement on our website at lifetimeincome.co.nz. And before my tongue ties up again, I will ask Martin this time to go through disclaimers for both Liz and Martin. So as you start talking, I will put the disclaimers on the screen.
Yeah, okay, thanks Chelsea, and good morning everyone. I've got a few disclosures that I just want to make very quickly. First of all, I'm a director and a small shareholder of Lifetime Income. I'm also an investor in Lifetime Income, so I have quite a lot hanging on Lifetime Income. Second, I'm the chair of the Summer KiwiSaver Investment Committee. I'm also on the board of the New Zealand Shareholders Association. I'm a financial advice provider, and my disclosure document's available on my website, which is www.martinhawes.com.
Fabulous. And Liz, anything to add there?
Just that, yeah, I'm also a financial advisor and have a financial a FAP, as they call it. I'm a financial advice provider. My disclosure information is available from enrichedretirement.com. But I really do encourage people to go and get personalised advice from an advisor. What we talk about today should not be considered to be personalised advice.
Perfect. Fabulous. Right. Well, as we've got, I think, a number of questions to get through. So I'm going to really start off the bat and say to Liz, can you tell us when is the best time to start thinking about your estates?
Well, today, really, because, everybody needs to have a will as a starting point. So if you haven't got a will, please make that a number one priority. Give somebody a call later on today and make a time to go and get that sorted out. So when you do a will, of course, you have to think about what is going to happen to your estate. And this is something to just keep an eye on over time, because circumstances do change. So every now and then you do need to take out your will, have a read through it and say, is this still relevant for my circumstances? Relationships come and go, or, people that are important to you pass away. So, or new people come into the family fold. So you do need to be constantly thinking about it. And I guess especially though, at the point of retirement, it's a really good time to have a close look at what your future plans are for your estate. But honestly, I can't stress enough the need to plan this ahead, because life can catch up with you. You can suddenly become unwell, and I have one of my very best friends passed away suddenly without having signed her will or thought through her estate planning, and that caused a lot of problems for the family. So you do need to get onto it and work out how you plan to deal with your estate.
Yeah, I have heard and been involved in stuff where if there isn't a will or a current or updated will, it can cause huge delays for the family.
That's right. And it's
Just
expensive
stress
as
at
well.
a really hard time as well. Yeah, it's expensive. There is no will, and a lot of stress on the family during what is a hard time. How often do you check your will and review it, Martin?
On sort of 2 occasions. I do it quite regularly, probably just mentally, because I think that events have a habit of creeping up on you. I've had a real interest in family trust, will, succession for 30, even 35 years, and I've written extensively about it. And I sort of come from this in a way that first, sometimes events creep up on you. They gradually kind of happen. Life happens, and it suddenly turns out that you're in quite a different position than what you were before. And that's why I think, I'd really agree with Liz, and I think yourself, Chelsea, that you need to do this on fairly regular occasions, but also when there are big events. Whether that's you're shifting house, you're going into retirement. I'm going to sound like a miserable bugger now, but relationship breakups, somebody dies. That ought to be a trigger to have another look at what you have and what you might want that has changed. Because a change in circumstance may well mean a change in your will or your family trust arrangement or any of those kinds of things. Or I should have had in there power of attorney, enduring power of attorney. That it may be that needs change as well when, say, you get some kind of health difficulty or diagnosis. So I'm really sorry to say it, because for a lot of it fascinates me, this whole area of wills and trusts and so forth, but it's got to be fairly much front of mind.
Just and talking about wills, where would you guys recommend people go to help sort their will out?
Well, obviously, really to their solicitor. So that's the first point. You can, get templates for wills online, but honestly, I would not recommend that. There's so many things that can go wrong, and especially nowadays with so many complicated family arrangements, with relationships coming and going. So yes, you need to make sure it's done properly, and so there's no room for anybody to contest your will, and to make sure your assets go to where you intend.
Yeah, I think that's really good advice. I'd go a little bit further and say one of the other areas you might go would be the big trust companies, public trust, perpetual guardian, trustee executors, and so forth. They do succession and not a hell of a lot else. And also just be careful with your lawyer. You may have a very good commercial lawyer or a very good property lawyer, or a very good divorce lawyer or what have you. They will all pretty much do wills, and they'll all pretty much do trusts. But it may be, if there's any complication in your affairs at all, it may be that you are better to go to a more specialist lawyer, just like you go to a specialist doctor. My circumstances changed a lot 2 or 3 years ago. One of those changes, only one, but one of them was I moved from Queenstown to Christchurch, which is where I am now, and I used that as an opportunity to change my will, and I'm delighted I did, because the old one was out of date.
Excellent. So as we're thinking about our estates, Liz, what are some key things we should think about when we start to think about or rethink about our estate as we head into retirement?
Well, I think one of the really important things to consider is, how much do you want to leave behind? So, my philosophy, which I've espoused on numerous occasions, is that all money needs to be spent by somebody, because otherwise it has no value. So I think a key thing is, what are your thoughts on leaving a bequest for your children or your grandchildren or a charity? So of the wealth that you have, how much of it are you going to spend, and how much would you want to pass on for somebody else to spend? And it's a really important decision, and that's a very personal one. There's no right and wrong answer to that. People have different views. I find now that most people would plan on, say, leaving their house for their family or the beneficiaries of their estate, and whatever other funds happen to be left after they've had a good crack at spending them. So that's pretty much the common approach, but it's not for everybody. Some people do want to leave behind a substantial estate to make sure their children are set up well. And another option, though, is to help your children during your lifetime. So it's about when do you want to help them. I think also, if you are planning to leave a bequest, you can think about investing that slightly differently, because that money is not going to be spent for quite some considerable time, but it'll be invested until the day you die, if you're planning to hold on to it till then. And so you can kind of earmark kind of a notional bequest, I think, and invest that in growth assets, with the knowledge that if you need to dip into that money, you can during your lifetime. But the idea is that you kind of ring fence an amount that can form part of your estate. So that needs a different investment approach. I think the other key thing to think about with estate planning is fairness and transparency, in terms of how you deal with your children. And we quite often see things go very wrong, particularly when there's a lot of money involved at the time of somebody's death, where families start arguing about who's had what share during the parent's lifetime or whatever, and is this fair that how is it split? Should it be split equally, or
Interesting thing there, and I'm not an expert on this subject matter, but I was talking to a lifetime customer actually who specialises in family law, and there's a new law coming into place that actually says that adult children can no longer contest a will. And I don't think it's coming in, but it is something that is going to come in, because they believe once your children are adults, you have decided what they can have. And what can happen is adult children who are left out of wills can start contesting the will and basically drain the estate. I just thought that was really fascinating. And I personally don't know when it's happening, not an expert, but it's just a subject I'd heard about, which
is. But I mean, whether they actually formally contest or not, you quite often still get arguments within the family anyway, and it can lead to great divisions between siblings, and it can be very messy. So you just got to make sure that everything is fair and transparent.
And Martin, is there anything any other things that you think are key that we need to think about?
Well, I think first of all, I think that the idea of a family arguing over, or my family arguing over my estate or the money I have now, won't be there to see it, but it's just appalling. I just cannot imagine anything worse than my three children with various other hangers-on, going into some kind of bitter dispute over what I've left them, and particularly if it's because I haven't left it clearly enough. My advice to people on this is that there's an awful lot going on when you approach a solicitor or you approach a trust company to get this done. There's a lot of jargon, there's a lot of terminology that you may not understand. And when that kind of thing happens, when there's a lot of moving parts, I like to sit back and think, what am I actually trying to do here? And I think with the work with wills and estates, I think you've just got to sit back and say, when I die, or when we die, what do I want to happen? And if you get really clear on what it is that you want to happen, you can then hand that package to a professional, solicitor, trust company, whatever, and let them use their professionalism to sort out how that's going to be arranged. Because we can all get into, well, we might need to do a property sharing, matrimonial property sharing beforehand and divide our assets, and we may need to use family trusts, and we may need to do that. That's probably not your decision to make. Your decision to make is to decide what you want to happen within the family, and then let the professionals figure out how that can be done without any family member trying to dispute the will or create arguments about it. Now, I would never do this, not in medicine, not in finance, not in accountancy. I'd never just give the professional the thing and sit back and take no notice from there on. But it's up to them to come up with the technical solution for you to provide the best way to achieve what you want to happen. And so I'd focus from your point of view. I think you should focus on what it is that you want to happen. So, and that's pretty simply what should go to whom. So it's, I'm making it sound very, very, very simple, but there might be a lot of technical stuff in the background. But I think from your point of view, you've got to be really clear who should get what, basically.
Yeah. Now, Liz, I want to round back to, you mentioned around giving to children and maybe grandchildren and when. And I think there's a little bit of a trend now of giving while people are alive. Can you speak to that?
Yes, well, I think, a lot of people have been helping their children buy houses, particularly with what's happened in the property market over the last wee while. And that's a really good thing to do. I think, it gives a lot more satisfaction, I think, when you can see the difference you can make to your children or grandchildren. Why wait till you, why make them wait till you've passed away, and then, and also helping them at that key point in their lives that can make a huge difference to the trajectory they're on, in financial terms, that can just give them that leg up. There are a couple of things to watch out for in doing that. And one is that if you are giving money to children, just bear in mind the Property Relationships Act, so that a gift to your child can be considered to be relationship property. So one way around that is to, rather than give money outright, have a loan agreement, which your solicitor can quite easily draft up for you, that says this is a loan that is repayable on demand, it has no interest, but it just means that in the event that your child's relationship ends, half of your money doesn't, walk down the road with the other person, the person that's leaving the relationship. So you do need to protect yourself in that way. The other thing to watch out for is the gifting rules for the residential care subsidies. Now, I'm not sure to what extent that's really an issue, but the current situation is that you can gift, I think it's $27,000 a year per couple, and that's, they look back, throughout your lifetime, basically, to see the gift that you've done before you apply for a residential care subsidy. Now, my thought on that really is that for most people, it's a bit of a non-issue. While most people, a lot of people say 40%, I think it is, of people might die in residential care. They don't tend to stay there very long. And if you're looking at something that might happen in 20 or 30 years' time, I think the rules are likely to change again over that time frame. So I wouldn't be too, too worried about that, but it's something you should consult with your solicitor on before you gift money to your children. So if it's a large amount, particularly anything over 27,000, I would say talk to your solicitor and talk about whether you need one of those loan agreements, talk about any impact on the gifting rules for residential care subsidies, and then take advice based on, do what you want to do based on that advice.
And Martin, anything to add there?
Yeah, well, I've just been through this with one of my daughters, so I've become the bank of Martin. Banks don't like you lending money to the children. They like to see it as a gift if it's a major part of the deposit. So you get into a bit of a cleft stick there, and that can be quite awkward. One thing that I would like to say to people is don't forget gifting to KiwiSaver accounts. One of the problems with gifting to younger children, I'm probably thinking for most people listening to this, I'm probably, think of your grandchildren, is that if you gifted them and they got, let's say, $50,000 from your estate, and they get that when they are 18, that's probably a very nice motorbike, or a couple of very nice trips overseas, or I don't know how many different surfboards or those things. If instead of, and this is something I have done personally, if instead of gifting to those younger children directly under your will, have your will say, I gift that to their KiwiSaver account. It means that KiwiSaver account remains invested, and the only way it can be touched is for them to buy their first house, which I would say was a good cause, a better cause than a motorbike or multiple surfboards or wherever else it might go. So I've got 4 grandchildren, and under my estate, each of them get, I think it's $50,000, and that comes off the top. That's the first gift under my will. So they each get 50,000, and then the 3 children share the remaining. It's actually very straightforward. But I don't know when I die. I'm rather hoping it might be 30 or 40 years or something like that, but it may not be. It may be tomorrow. And one of my grandchildren is 9 months old. So, she's not going to get the money now. Toys R Us would be absolutely delighted if she did. She's going to get that when she's probably 25 and going out to buy a first home. And I'm hoping that what I've done with each of the grandchildren is they each get $50,000. That will grow in the KiwiSaver accounts, and it will provide pretty much a deposit for first time. KiwiSaver is a really good way of giving money to children, because they can only use what's in the KiwiSaver for good purposes.
I really like that. That's a very good idea. Liz, I'm going to throw you a tricky one, because more and more these days there is kind of amalgamated families. So you end up, in your older age, you might have a new partner who has 3 children, and you've got 3 children yourself, and you end up with 6 children. What do you do? And how do you manage kind of multiple children to give to?
Yes, look, this is a really tricky situation, and you do need to get really good legal advice on this. And I've seen some horror stories. I've seen an instance where there was a blended family, and the husband passed away. They had sort of mirror wills, if you like, set up, so that if anyone died, the estate went to the surviving partner, and then on that partner's death, it was split equally amongst all the combined children, the blended family. But in this instance, the husband passed away, and the wife, surviving partner, then changed her will to cut out his children. And there wasn't a lot that anybody could do about that. And the other situation I've seen is where one partner has died, and then you have a situation where you have stepchildren who are desperately waiting for the step parent to pass away so that they can sell the house and receive their inheritance. So, you do have to think about the personal dynamics that come into play here. And it's not always easy to capture that on paper in a will and to predict every possible outcome. So, I think as Martin was saying earlier, you do need to think, what is the outcome that you want, and how can you possibly treat everyone fairly? How can you avoid these situations where people get cut out, or where, someone's waiting for their step parent to hurry up and kick the bucket, and especially if there's a bit of an age gap. It's not easy. And what I also see sometimes is that people put it in the too hard basket. They don't deal with it because they don't know what the solution is, and then something happens and it's a big mess. So you really have to confront these issues. But also, I think, as time goes on in a second relationship, your views about that your new partner and their family can change. So when a relationship's quite new, it's a little bit different than if you've then been together for 20 or 30 years. And so you do need to update, I think, your estate planning documents to reflect that. And another horror story I've seen is where an elderly man, and it was in his 80s, he had been in a second relationship. His wife passed away, and under the terms of what they had arranged, the house was to be sold within 6 months of her death, so that she could pay out to her children. And all of a sudden, here's this man on a walking frame in his 80s, having to find somewhere else to live, and couldn't afford to buy a house outright on his own, so he ended up renting. And so there's lots of terrible things that can happen. So you do really need to think it through properly, and especially with second relationships, revise your arrangements as that relationship progresses.
It goes back to what you guys are both saying about making sure you look at it regularly and be transparent with people, I think, as well, so that there's no surprises there. Anything around amalgamated families from you, Martin?
Like Liz, I've seen a lot of things that I think could reasonably be called horror stories. It's an area where you may have to have a difficult conversation, maybe even a series of difficult conversations with different people, possibly a new partner, possibly with some of their children. It depends a lot on their ages. I hate it when people are presenting like this and they say it depends, but it does so much depend, and it's a very individual thing. Of course, time goes on, but time may not go on for some people. We often have no idea when we're going to die, when a will or when this is going to be put together, and the children could be young, and maybe you don't die until the children are in their 30s, or maybe you're expecting to live for a long time, but maybe you don't. There are so many maybes that I think it's a very difficult area, and I think that there's a very wide range of possible outcomes, but also a very wide range of things that people will want to happen. And I don't think there's I got this question from you, Chelsea, last night or yesterday afternoon. I've been thinking about it ever since. Is there a set of principles that we could apply to this? And I can't come up with them. And I do think this is where you've got to work through your individual situation. And I hate saying this as a presenter as well, but get some really good specialist advice on it. And probably from people who have got a bit of grey hair, where they've seen it before, they've seen they've seen the sort of circumstances that come out. They might be able to guard against as many circumstances as possible. So I'm really sorry. I have no set of principles, and I certainly don't have an easy fix for this one.
So we talked a lot about giving to families and situations with families. Liz, what about those people who have decided they're going to give to charity? How should they go?
Well, look, yes, well, I think, Kiwis are very generous, very charitable, and I always encourage people to think about making charitable bequests because, you don't have to be wealthy in order to do so. Most people will have a house or some sort of assets, and I think, even if you die with $10 in the bank, you can still give 10% of that to charity on your death. So you do not have to be wealthy. Every person has the potential to give on their death because, and if, it only needs to be a small percentage. And I think if your children are arguing or, worried about 10% of the estate, which if you've got 3 children is, just over 3% of your estate each that they're giving up, then I think there's something wrong. So I think everyone has the power to give. And there's a number of ways you can do that, but also I think one of the advantages of giving during your lifetime, as opposed to waiting until you pass away, is that donations to registered charities are tax deductible, and you get a 1/3 of the amount donated back as a tax rebate. So long as you're giving up to the level of your not exceeding your income for the year. So I really encourage people, particularly in the late stage of retirement, when it becomes very clear that you're probably not going to use all of what you have during your lifetime, rather than wait until you pass away, why not do some charitable things in that late stage and get your tax rebate? It's a much more effective way to do it, and then you can even donate the rebate and just keep going on in perpetuity donating your rebates. But also, if you are in the lucky position of being fairly substantially wealthy and you have you can think of setting up your own charitable trust, I would really advise against that because we have way too many charitable trusts in New Zealand. They are expensive to maintain, and it's often a problem finding successful trustees to run them. But throughout New Zealand, there is a network of community foundations, and I have to declare a bit of a conflict of interest on this because I'm the deputy chair of Wellington's Community Foundation, which is the Nico Foundation. But they are setting up an endowment fund, your own named endowment fund through a community foundation is a far cheaper, more cost-effective way of leaving a bequest which stays in perpetuity. The funds are invested and the returns from the investment are paid out to the charities of your choice every year in perpetuity. So there's just a couple of things to think about. Everybody can give. Try and give some during your lifetime to get the tax rebates, and think about the Community Foundation approach. Just go to Community Foundations New Zealand website and you can find the one in your area.
That's a really good idea. The other ones I know that are around right now are websites like the Good Registry, which is probably a bit like that, where you can kind of go and select a whole lot of different places, and they're doing some really good things. So you can definitely get help on that side of it. And Martin, what about you? Have you got?
Well, I'm sort of wiping the sweat off my brow actually, because I was wondering where Liz was going to go with this, because I was going to talk about community foundations, and I was also going to talk about not a personal foundation unless you're very wealthy, and also I've often thought that I think you're Liz. Gifting in your lifetime is tax efficient, and I'm often, sort of on your last breath, you've got the pen signing a large gift is a far better way to do it than the charity receiving the money through your will. When I left Queenstown was just forming its community foundation. I think there are 26 of them or something in the country.
Yes,
and one of the things that I thought was really good was that I could basically nominate a group of people, and in my case, it was young disadvantaged people, because we think of Queenstown as a very rich area, and certainly it has got a lot of rich people in it, but there is an underbelly of people who are really struggling. And of course, their children, as in most circumstances, their children struggle even more so. So I've basically nominated for, and I think all I've said is for the young people of, or for children and teenagers of help for teenagers and young people in the Whakatapu area. And it means that, you know, charities will come, charities will go. You know, this may not be action for another 30 years, and who knows what charities to be around there. But hopefully I've given broad enough instructions of the people who I want to benefit, and I actually think that's a very good way to do it. But I've also had organisations like Save the Children and some others that I've been involved in, and you know, there'll be money for them directly as well.
Nice, excellent. So Martin, one right after your heart. Could I just use my family as trust rather than doing a will?
No.
That was easy.
Simple answer. You need a will, regardless of whether you had a family trust. The family trust deals with whatever assets it owns, and that is seldom absolutely everything. So the family trust can distribute at any time, but it can only distribute assets that it owns. And you are going to have some other personal property, and you're going to have to, your will deal with that. And of course, very few people have all of their major assets in a trust. They might have the house in a trust, but the business remains outside of that, or the investments may be in their personal names. So the will have to deal with any assets that you continue to own personally. But also you give instructions under your will, you know, like whether you want to be cremated or buried, or you know, some small items, ungifted debt. So you may have made loans maybe to the family trust, but maybe to the children, and you may want to, under your will, forgive those loans. And also the appointment of trustees doesn't have to, but can come under your will. So the appointment of, you're probably a trustee of the family trust, and your will say who you would want to replace you. So no, you need both, and the family trust is an add-on.
Anything else there from you, Liz, or is it a quick note?
Oh, just to stress that everybody needs a will. So
Yeah.
that's quite black and white.
There's an easy one.
And actually, I should add in that too. You know, make sure your children and grandchildren have one, because people have KiwiSaver balances now. You know, even young people who they might not have a house, but they have a KiwiSaver balance, and you know, without a will, it's the same torturous process, you know, to deal with that. So make sure that all your family members have a will as well.
Yeah, that's actually really good advice in terms of young people have more money saved away these days because of their KiwiSavers. So get everything. Now, Martin, should I wind up the family trust that was settled 25 years ago?
That sits somewhere between a possibly and a probably. And given the event of the Trust Act, I know we're going to come to that in a moment as well, it probably tends more towards a probably than a possibly. It really does depend on what are the advantages or what are the benefits that you were contemplating or hoping for when you set up the trust. And are you likely to still receive that benefit? Because whether or not you should settle a trust and whether or not you should continue with the trust comes down to basically it's a cost-benefit analysis, sort of a flash term for saying what are the advantages that might accrue and what are the disadvantages that I have for it. So the advantages might be asset protection because you have had or you still have a business. It might be a tax advantage. Or might have been a tax advantage. It might be risk care, residential care subsidy. It may be, if you go back 25 years, it may be that you've formed it because there was superannuation surcharge at the time. A huge number of trusts got set up for that. Now we don't have that anymore. So you've got to look at the advantages that you might get from a trust, and then look at the disadvantages, the cost of running it, the management time that you've got, the extra complication in your affairs. And there's a weighing up, here's the benefit, here's the cost, which one weighs more heavily. I'm saying this a lot this morning, but and Liz, you are as well, but this is somewhere where you might need to get some help. When you look at the benefit side of things, a lot of the benefits of family trusts are gone. So if you settled a family trust 25 years ago, that was about the time I wrote my family trust book. Now that's still in print. I've just updated it again because the Trust Act sold something like 130,000 copies. When I wrote the very first edition of that, I was talking up the benefits because there were a lot. There was tax, there was residential care subsidy, there was superannuation surcharge, and so on. There were quite a lot of benefits. A lot of those benefits have been, if not whittled away, they've been chainsawed away. They just no longer exist. On the other side of it are the costs, and the costs are actually weighing more heavily. So there's less benefit, but there's more cost. And that is why I would say that there are a lot of people who probably should wind up their trust. They're meant to be, nobody really knows, but there's meant to be something like 450,000 trusts in New Zealand. We are the most trusted country in the world per head of population by a long chalk. Nobody has trusts like we have them, and I would say probably, I'm guessing here, but probably a good half would be better off winding up the trust, getting rid of all that cost, getting rid of the management, getting rid of the worry of another entity, and because they are unlikely anymore to get much of a benefit from it.
In terms of the new Trust Act, is there anything that you haven't spoken about in which people should change in their family trusts?
The Trust Act's another factor in this whole cost-benefit analysis. And the Trust Act, which came in at the beginning of this year, it was enacted, I think, in 2019, but it came into effect in January this year, codifies a lot of law in New Zealand. It forces trustees to do things that they always had to do, but it's put down in black and white. And instead of the rules surrounding trust and their management being scattered over across half a dozen or even a dozen bits of legislation and vast amounts of case law, instead of it like that, it's brought it all together so that you can read the Act and you can see what it is that you should be doing. When you start to look at what's in the Act and realise the responsibility and the role that a trustee now, always had to play, but now really must play, the duties that they have are such that there will be a lot of people who will look at that and think, I'm not doing that, I don't want to do that, we're getting very little benefit from the trust, we may as well wind it up. This, I could go on for the rest of the day on this, and Chelsea, I promise I won't, hand on heart. But there are the duties. There are 5 mandatory duties, things that you have to do, and a dozen, I think it's 12, default duties, things that you have to do unless your trustee says otherwise. And there are things within that. So can I give you one example? You have to, now you've always had to do this, but you have to invest prudently. That's a default duty. Now your deed can say you can have some kind of eccentric investment strategy. For example, to have 6 rental properties and not a lot else. Now, if that went before a court, they'd get an expert in like Liz or me, and we would say, if this was an older person, we would say that is not for a trust, for an entity that is investing for other people, children, grandchildren, whatever, that is not investing prudently. That should be diversified. And so the trustee would be found that they're in breach of the trust, basically, because they haven't invested. Now, if there was a good reason for wanting to own just one asset, or just one even group of assets, then you could change the trustee to allow for such an eccentric. So there's all sorts of things like this happening. If you go back, I'll finish on this. If you go back 25 years, 1995 was when I wrote the first edition of the book, and I've updated it 10 times. So there are 10, I think it's 10 or 11 or 9 or something, editions of this book. If you go back to then, the lawyers had an absolute field day setting up trusts. Now, this year, 2021, they're having an absolute field day pulling in their clients who have trusts and looking at the trust arrangement and talking to the client about their circumstances now and probably winding those trusts up. And I feel a bit responsible for this because the book I wrote on trust did give a fair bit of impetus to trust, and it has done very well. But all I'm trying to do with trust is call it like I see it. And I think the way I do see it is that we're now in a situation where a lot of people would be better off winding up their trust.
Thank you. Now, we are rapidly running out of time, so I am going to jump to the last question, which I think is actually one of the most important questions we have on here. And I'm going to start with you, Liz. Enduring powers of attorney, why are they important? And how do we set them up?
Well, I think, these are really important because, health issues can strike at any time. And once you've basically lost your marbles, it becomes a very difficult process to get things done. So enduring powers of attorney, there's 2 types, one for your financial assets and one for your, care and welfare. And they are really important documents to have in the event that you become mentally incapacitated, because it's not possible for you to sign any legal documents if you're mentally incapacitated. You're unable to probably pay your bills or conduct your financial affairs. So you need to, before that happens, before you become mentally incapacitated, appoint somebody or people, it can be more than one person, to act on your behalf. And so you can set this up in a number of different ways. So you can appoint, successor attorneys. So you can say, well, I nominate, my son to take this role. In the event that my son is unable to do that, my daughter can step in to do it. You can have a requirement that the people you appoint need to come to some agreement between themselves before anything happens. So there's a number of ways in which you can ensure the protection of your assets and your welfare. And just bear in mind also that these things don't come into force until you're seen by a doctor and certified as being mentally incapacitated. So it's just one of those things that's it's really good housekeeping thing to do, particularly at the point of retirement. so that if you have a stroke or, some other adverse, or suffer from Alzheimer's or dementia, that people can still sort out your affairs and make sure you're well taken care of.
Anything to add there, Martin, from your...
Not really, Liz. I think that's a really good summary of the whole thing. And I'd underline the importance of it, because it may not be dementia. It may be a bang on the head. It can be a whole range of different things. We're really talking about capacity when we're looking at this, and there've been lots of legal cases on whether or not somebody has capacity, and to have an attorney. Doesn't have to be a lawyer, it can be your daughter, it can be your son, but to have somebody who sits in as your attorney under an enduring power of attorney that's been properly done up, and there's quite a bit now to make sure that you're properly advised and so on when you do this. It takes a lot of that capacity problem out of it. Did Granddad have capacity when he signed over the farm? All of those kinds of things. It gives a lot more clarity. I keep back, and this keep coming back to, and Chelsea, this will be my final remark. I keep coming back to that. This stuff is to keep families friendly.
Yeah.
It's to stop families falling out and fighting over stuff they should never fall out over, and that's what makes it important to me. It's that families live together and play together and are together.
I absolutely agree, and I think the key things that you've both kind of mentioned is get advice on these subject matters. It's really important to talk to people that know, be open and transparent with people. Particularly family members, so that they know, and they know what's coming, so there's no surprises for them. And I think finally the main thing you guys are saying as well is to keep reviewing. It might be once a year or when major milestones happen, but if maybe you say every Christmas when you get around with your family, you review all your estates and wills, and that triggers in your mind because you're with your families, and you can talk to them at that time as well. So it's a really good opportunity as we head into Christmas that, maybe it's a good reminder to start having some open and honest conversations with your family about what you've got planned if you haven't already. We will wind up there. Really like to say thank you, Martin and Liz, again. I think this was, there was a lot of really practical advice in there, and some people might have to go back and watch it again because there's a lot of information, but also a lot of practical advice that people can use going forward. I'd like to talk about our next webinar in a couple of weeks' time. We're really fortunate to have the Retirement Commissioner coming in to join Ralph in a conversation about what the Commission does, what it does for retirees, and perhaps some challenges we're facing as we go forward. So that's going to be really exciting. That's Jane Wrightson. And then we look forward right till the last one on, I think, about the 14th of December. We are going to get Diana, our board chair, in with Martin and Liz. And we are going to, I should say Diana Crossan. Not everyone knows her full name. So we're gonna have a really good chat, and perhaps Martin and Liz might talk about a couple of the upcoming projects that they've got and been working on. So that might be a nice little treat if they're kind to us. So for now, thank you very much for joining us. As always, if you've got any questions or subject matters that you want spoken about, please do get in touch. We'll be designing up a schedule for next year. So if there's anything that you would like us to talk about, please do let us know, and we'll add it in. And thank you again. Thanks, Martin. Thanks, Liz.
Thanks, Chelsea. Thanks, everyone.
Thank you.